litigation between Wynn and Fontainebleau over the attempted hiring of Wynn employees and executives has heated up recently. Wynn filed a lawsuit against Fontainebleau alleging intentional interference with contractual relations. It claims some of the executives hired from Wynn had non-compete clauses. Meanwhile, Fontainebleau filed a counterclaim accusing Wynn of intentionally interfering with Fontainebleau's contract with an executive it had a contract with, resulting in that executive backing out. So what is exactly intentional interference with contractual relations, and how enforceable are employment non-compete clauses here in the state of Nevada? Joining us now to discuss it all, we have attorney Matthew Hoffmann with Battle-Born Injury Lawyers. Matthew, thank you so much as always for joining us. This is an interesting one because it has our newest, one of our newest facilities here on the Strip, as well as a mainstay. So this lawsuit, as we mentioned, it was brought on by Wynn, and now the counterclaim by Fontainebleau. Kind of explain to us what exactly is happening here. What are they accusing each other of doing?
Yeah, you've got the main claim being this intentional interference with contractual relationships, which on its face, as far as, what is that? It's exactly what it sounds like. It's, but it involves a certain level of knowledge. So you got a company that has an employee or an executive that's under a written contract. Another company wants to get them to come over to them. They know this person has a contract with the other employer. And despite knowing that, they start scheming with this person. Hey, you need to break this contract and come work with us. That is a claim. You can do it, but you can get sued for it. The key is going to be whether they knew that these contracts existed. I'm guessing that, the argument to that's going to be everyone knows these contracts exist because it's industry standard. We're going to have contracts. We're going to have non-competes. You know this. It's an interesting case because while the Fontainebleau was being built and their team was being assembled, their leadership team, they were all staying at the Wynn and the Encore for, I think, over a year. So what I'm guessing happened is relationships developed. They were rubbing elbows with the same people. They had a mass exodus of people. I think it was in December or January after their opening. And where better to get people than where you just were staying and you got to know people. So I think it's interesting to see the allegations back and forth. It really comes across as quite personal.
Yes. So when you have the non-compete in place, let's talk about that. How enforceable is it really?
Yeah. So non-competes, there's several states where they're just never enforceable. Nevada is one of the states where they can be enforceable. They are, the statute was changed, I think in 2021. You cannot have non-competes for hourly wage employees, but you can have them for salaried employees. And they're very common with executives because, think about it, executives have access to high-level information, confidential information, trade secrets. The key is you have to be paid for it. You have to have some kind of a compensation for the fact that when your contract's up, you can't just go move next door and work for a competitor. You might have to take a year or 2 years where you can't work within the city. There's going to be geographic limits and there's going to be time limits. The key to it is they have to be reasonable. So, if you had something that said you can't work within 500 miles of Las Vegas for 5 years after you leave the company, I don't really care how much you get paid for that. That's probably going to be seen as excessive and not enforceable. But if it's something like 1 year and 50 miles and you're paid for it, that's enforceable. Go work in Reno, go work in Biloxi, Mississippi, go, whatever the case may be. So, here you've got Fontainebleau and Wynn Las Vegas are virtually next door. They're right up the street from one another.
Right.
They're all going after the exact same client base, high-end clientele, and the general public. So you can understand the concern that they would have with poaching executives with, trade secret information, marketing strategies, things like that, and then access to high-level gamblers, whales. So it's going to be interesting to see what happens with this. Usually these are resolved before lawsuits are filed. So this one, it seems really personal. I'm going to assume it's going to get resolved, but you never know.
Time will tell. Well, thank you so much, as always, for breaking down the law. And if you have any legal questions for Matthew Hoffmann, you can always email us. And you saw that on your screen. It's up again. That's breakingdownthelaw@news3lv.com.